Good afternoon, everybody. My name is Chris Justice, and I am an employment lawyer with Samfiru Tumarkin. And as always, I'm here to hopefully answer as many questions as I can within the time permitted. So all things to do with employment law. Maybe you've got a question about a contract you've been asked to sign. Maybe you're going through something at your workplace from a fellow coworker or boss or manager. Maybe you've been let go and you're wondering whether or not the package that was offered to you is sufficient. Whatever it may be, definitely get your questions in today, and I'll do my best to answer as many as I say within the time allowed. But before we get into some of your questions, as I normally do, I like to start off by talking about maybe a recent case of mine or some news that's been going around lately. So to start for today, I wanted to talk a little bit about some news, something I've actually talked in the past before on. This time it has to do with Ontario public servants are being asked to resume office in person full time starting next year. So the Ontario government in this case is requiring a full-time return to the office for these public servants. Starting January 5th of 2026, 5 days a week. Now, before getting to that point, they've got, as I understand, a hybrid model, and they're looking to ramp up the in-office work before next year to 4 days a week starting in October of this year. So there does seem to be a shift or a sort of a push towards eventually trying to have employees in these sectors come into the office, as I say, 5 days a week in person. This also includes a lot of major employers like banks, the big banks. They also are wanting staff to be in the office, if not all the time, then most of the time. And I think this can raise some important questions as far as what somebody's options or choices are if they're being asked to come into the office on a full-time basis. A lot of people, as we've spoken about before, were told to go back and work from home or to work remotely once the COVID-19 pandemic hit. And in many of those cases, after what looks like maybe 4 or 5 years down the road, they're still working from home or working remotely. But it will depend on each case, his own facts, sort of a case-by-case basis as far as whether or not an employer in any given scenario does have the authority or the legal right to demand or insist that you come back to the office full-time, even if you may have been working remotely. So if an employee's contract, so something you may have signed months ago, years ago, if you look at the contract and that contract says specifically that the remote work from home or the hybrid model of working some from home and working some from the office, if the contract says that this was only to be a temporary arrangement, so you've signed something saying this is only a short-term fix, but it's not to mean that you're now going to be allowed to work from home indefinitely into the future, the contract could be a possible issue for employees. So you definitely want to always look back and see whether or not you've signed anything that would sort of give your employer the ability to have you come back in the office that would say this is only a temporary arrangement. If there's something like that, then the employer, so your company, may have much more of a ground to stand on when insisting you come back to the office. And it wouldn't be considered necessarily a constructive dismissal. So you wouldn't be able to treat that as you would a termination and go after the company for your full severance. So that's the starting point. Did you sign anything or otherwise consent to the idea that this hybrid or remote arrangement was only supposed to be short-term and nothing indefinite? But on the other hand, remote work or hybrid work may have become a big term of your employment that hasn't had any change happen to it for many months or many years. So again, you might be in that situation where maybe before the pandemic hit, you had a job where you had to go into the office every day. But since the pandemic hit and for the last 4 or 5 years, you've been working from home without issue, your performance isn't being affected. Well, I think in that particular case, you as an employee would have much more of a leg to stand on to say, I don't want to go back into the office. I've been working remotely now for several years without issue. And now you're coming to me and asking me to go back into the office. Well, my expectations now have changed because of the last 3, 4, 5 years of me working from home. I now reasonably expect that to continue on without any interruption. It's one thing for an employer to maybe grant a temporary remote work position for a number of months with the understanding that you'd come back shortly after that. But it becomes a bit different of a situation when those months turn into years. And then year after year after year, you've been doing it, as I say, without issue. And again, as long as you haven't signed anything that says the remote position or the hybrid nature of your role is just temporary, then I think the employer is going to have a much harder time trying to convince a judge that it is a fundamental term you work in the office if that's not been the case for several years running. So you want to, as I say, assess it on a case-by-case basis, but there are definitely going to be situations where you're working from home, you're given a notice from your employer saying, we want you in the office 4 or 5 days a week. You may have the ability to say, nope, I don't agree to that. I will continue working from home as I have, as I've proven I can do. But this requirement for me to come back into the office now after years of doing it outside of the office is now a change to the terms of my employment, because the terms of your employment can morph and sort of evolve over months or over years, depending on what happens. And you're not always going to be held to simply what you've signed in a contract or a piece of paper that's maybe 5, 6, 7, 8 years old or older. So there could be a claim for constructive dismissal, but you definitely want to give us a call. You want to get some legal advice before having any major communications with your employer around the return to work. Before stating your position clearly to them, you want to get that advice first, so that if you are going to say what you're going to say, at least you know what options you may have in the event that there's pushback, or you may know that by saying what you need to say, that could cause an end to your employment relationship. Whether or not you're owed severance, that'll be a question. But as I say, all the more reason to get advice before sort of taking a stance and going back to your employer with that position. So I thought that was good, just a topic to talk about off the top, because as I say, it has been something that's going around in the news a lot. And I find that specifically since about 2024, when employers have been calling people back into the office, that these people stood a good chance to say, no, I want to remain at home. Whereas on the other hand, if you had been off working remotely, let's say in 2021 and a bit of 2022, and you're called back into the office because your employer was saying this was just a temporary sort of COVID measure, that's one thing. But to wait until 2025 or even maybe into 26 before demanding someone come back in, I think at that point, a lot of employers simply have waited too long, and now it's going to be next to impossible for them to go back. But if they still insist you go back and they don't want you working remotely, then that could signal an end, but at least you're going to get your full severance as a result of that, and hopefully use that time and money to try to seek employment elsewhere. Another sort of factor to consider when it comes to coming back into the office, demanding people come back into the office to work in person when they have been at home for many, many months or years, is to consider the human rights overlap here as well, because you may have been, or you may be somebody working from home or working remotely, and it may be beneficial to you because you have childcare responsibilities, or maybe you have a medical condition that prevents you from being able to go in office to work as your company may be asking you to. So there could be that human rights overlap where you actually have a ground under human rights legislation, whether it be family status, disability, could be a number of things that may make it even more logical and necessary for you to stay working remotely or stay working in a hybrid situation. And I think in these particular cases where somebody is asking for an accommodation or some leeway to continue working from home, specifically because of, say, disability or family status, then I think there's going to be even more pressure on your employer to grant you what you're asking for, to allow you to continue working from home. Because if they get wind of there being a disability issue or a family status issue, and they still insist on having you come back into the workplace physically, then that could not only be a constructive dismissal, and so you'd go after them for your full severance, but now you're getting involved these human rights aspects. So there could actually be a failure to accommodate a human rights violation by the employer insisting you come back despite having maybe support from your doctor, or despite having evidence to show that you've got maybe 2 or 3 kids at home that you need to look after, that you can't maybe have daycare look after or somebody else look after because those are your circumstances. So I think it's a lot more for employers to consider and sort of think about before they just insist on sort of it being their way or the highway, because they could open up that big can of worms and expose themselves to even more damages. I'll get into some other topics I was going to touch on at the top of this show, but I do want to get into some of the questions first just to make sure I answer as many as I can. So I've got one in from Wild Assignment on Reddit who's saying that they just started a 1-month medical leave for burnout and stress. And after the first week, they realize they don't want to return to working in that environment. Their contract says that they have 2 weeks of notice, or they have to give 2 weeks of notice, presumably for a resignation sort of situation. And they're asking if they're allowed to quit during the medical leave that they're on, or do they have to wait for their return to work to quit? And they do mention having some job leads for after the break, but they just don't want to go back. So that's entirely fair. You might think, this place is too stressful. I'm getting burnt out. I don't really want to continue working here. If anything, just for the betterment of my health, maybe there's some other opportunities you have. So I think it's completely fair to inform your employer if you truly are voluntarily wanting to leave, to let them know. I think in a case where you're on a medical leave for a month, you've only been on that leave for a week or two. So at the very least, I would imagine the employer would expect you to come back no earlier than over the next 2 weeks. If you really do want to leave, I would suggest letting your employer know even while you're on the leave, and that be that. And if the employer responds to say, well, we need some notice, or refers back to your contract, I would say you want to give us a call at that point for sure before you say anything else. But I do think that if you're going away for a month, you've been only a week or two into your month-long leave, and you give your employer notice right now, that's 2 weeks right there. And they wouldn't have expected you to come back before that in any case, because your leave of absence was for at least a month, if not longer. Sometimes these medical leaves get extended even further. So it doesn't seem to me like there's going to be a big issue in as far as them trying to say that you need to be actively working there for 2 weeks in order for that notice to take effect. I don't think that's the case. But you may also want to consider the context of why you're leaving. So I think there's a difference between somebody voluntarily resigning from their job for no reason or no fault of the employer, just maybe because they don't think they're a good fit and they want to seek greener pastures elsewhere. But then there's another context where someone quits or leaves their job specifically because of something they went through while they were working there. This may not apply to you particularly, but in general, if somebody is being felt like they're being pushed out of the workplace, that they're maybe going through issues of harassment in the workplace, maybe their boss is stressing them out a lot, maybe it's not just the work in general, but someone is doing something improperly or inappropriately that is causing your stress, and that is almost sort of, as I say, pushing you out the door. You may want to give us a call as well before you even give your notice, because there could be a situation, like a lot of cases, where somebody gets pushed out, maybe not ideally, they don't really want to, but say they're being harassed by their boss and they leave because it's stressing them out. That could actually be considered a termination, which is a bit different than your sort of standard resignation where there's no issues maybe going on in the background. And a lot of time people are pushed out of the workplace, basically almost forced to quit. And they then later claim they were constructively dismissed, that they quit specifically because they went through a number of things in the workplace. Maybe they tried to get them rectified to no avail. And now they're left in this position where they feel forced to have to leave. As I say, that can be characterized in a lot of cases as a wrongful dismissal. And you may be entitled to severance and not treat this at all like your standard or your typical resignation. So I'd say give us a call just to get a better sense, I think, on the reasons why you've left or want to leave, and maybe what happened in the workplace in the build up to that. But certainly after that's communicated in whatever way it is, if there's any pushback from the employer as far as not giving enough notice for any kind of resignation, if that's what it is, definitely give us a call at that point too. Because I think in that case, you're fine either way, but I'd want to delve a bit deeper into the reasons why you left and maybe see if there's another option or two for you that you may not have considered. But thank you for your question. I've got another one in from Shraddha on Reddit who's saying they recently started a restaurant job in Ontario. They've signed a contract that requires them to give their employer, it looks like 45 days notice to resign. So that is, what is that? It's almost coming up on 45 days, 7. So yeah, so you're talking about several weeks for sure, not just 2 in the last in the last question I answered. And they're saying there's training pay after 6 months. After working 4 days, I decided to leave due to feeling uncomfortable and the trainer being rude, but HR responded saying that I'm legally required to stay or face consequences under ESA and Canada contract law. I don't want to continue. What are my options in this situation? So again, similar to the last question I answered, you're mentioning feelings of uncomfortable, trainer being rude. So I then question again, why is it that you want to leave? What exactly is making you feel uncomfortable? What is the trainer saying or doing when you mention being rude? Because this could also be a situation where maybe you don't really want to leave, but you're now being put into a position where you just can't take it anymore and you have to leave, which, depending on what conduct you've suffered or what conduct they've sort of done towards you, that could also be characterized as a potential wrongful dismissal for which you might be even owed severance. There is, in some cases, a situation where if you don't give enough notice of resignation, that your employer can sort of go after you in one way or another for the amount of notice you didn't give. So, for example, if I have a contract that says I have to give 5 weeks of notice before I resign, and I only give my employer, say, 2 weeks, there are some scenarios where the employer could say, well, you didn't comply with your resignation notice clause in your contract. You've given us 2 out of 5 weeks. We want the other 3 weeks. And they could, as I say, potentially go after you to try to claim those 3 weeks. Whether or not a company would do that, given all the work and money required, is another question. I would like to think that probably a lot of employers aren't going to do that over a couple weeks or so. But certainly if it gets more or those weeks are worth a lot of money, they could. But that's only assuming that the resignation in your case is also clear, it's unequivocal, there's no bad faith conduct on the company's end that kind of led you to resign. So I'd want to also kind of delve a bit more into your situation and find out whether the company has any leg to stand on, even if they did have you sign a contract, or whether there might be some arguments or positions you could take to kind of fight against that, give yourself more of a leg to stand on to maybe get severance, or at the very least just leave, cut ties, and move on to your next path. So I think just like wild assignment on that last question I answered, I'd recommend you give us a shout so we can kind of delve into it and just make sure we're giving you the appropriate advice. I've got another question in from Paul on Facebook who's asking whether their employer can unilaterally extend a notice of termination. So this would be a scenario where I presume you're being told, let's say today, that 6 months from now, you're going to be let go. And then maybe before that 6 months comes to an end, your employer says, well, actually, we want to extend the notice of termination. So instead of giving you 6 months before you end, now we're going to extend it for another 2 or 3 or 4 months. I think in some cases, employers cannot do this. It's almost a scenario of sort of the horse has left the barn already. I wonder, Paul, whether your employer also, on top of the notice they gave, offered you any severance. Usually, a lot of times, there'll be sort of a bit of both. So they'll give you maybe 6 months of notice or 6 weeks of notice, whatever it is, of being let go. And then they'll offer you some money on top of that. So if they were to extend the amount of notice and they offered money on top, are they now taking that money away? That's another question. And also, what is the environment like? So if somebody has been given notice that they're being let go, and then along the way, the work situation turns toxic, it's not going to always be reasonable or for an employer to expect that, oh, we can just extend the notice time after time after time again, knowing that there's toxicity in the workplace. Because a judge might look at it and say, this person, no reasonable person would stay around in this scenario. And so I don't think it's reasonable for employer just to extend the amount of notice. Typically, notice is not a bad thing as far as the law is concerned, because the whole idea of giving someone notice is to give them as much of a heads up as possible that their job is coming to an end, while also allowing them time to look for other jobs during that notice period. Because the law is just trying to look at making sure that if someone is let go, that after they stop working for that company, there isn't going to be a huge gap of time where they're just unemployed and they're out there trying to find a job, but they're not able to do so. So that's why notice is, generally speaking, okay, because it can give you the time to look for work while still keeping you on payroll. So again, probably another situation, Paul, I'd want you to just give us a call. We can even set up a free consultation to talk about whether they can extend the notice, number one, whether there's something going on in the workplace that would make that extension more, or I should say less reasonable, and also just whether or not you're owed more money in general. Because if somebody's being let go in Ontario, it doesn't matter if you're given notice, you're given no notice. In my experience, vast majority of the time, you're not being given what you should be given. So that might mean more notice should be given. That might mean more pay should be given. But most of the time, when you combine those two things together, it's still going to fall short of what you're probably reasonably entitled to. So I think all the more reason as well to give us a shout so we can kind of go through that and make sure that your overall termination package is good and you're not getting shortchanged. I've got another question in from Michelle on YouTube, who's saying that they work for a repo company in the US, but they're based in Ontario. They've been told that they don't qualify for overtime or vacation pay because of the state they operate from. Is this true? Odds are it's not true. So this I come across this situation a lot. You work for an American company, but you specifically work the entire time in the province of Ontario. Even if your company is from California or New York or wherever, the laws that apply to you generally are going to be the laws that apply in the province you're working in. So if I'm an American company and I hire someone to work, let's say even remotely from home in Ontario, I can't insist that all the laws that apply to the relationship are American. So you're going to be looking at things like, what does Ontario say as far as severance is concerned, or as far as vacation pay or overtime? So I don't know if the contract, or if you did sign a contract with this company. A lot of times, if you do sign a contract, probably near the end, it will say what the applicable law is. And a lot of times, even if it's a US company, it'll mention the law is still Ontario. So that's a big red flag for me. I'd definitely give us a call. It's not a surprise because a lot of times Americans get it wrong. And there is a big difference in many respects as far as the laws south of the border and here in Canada. But again, the main focal point is, where am I physically based out of? Where am I working? If I'm in Ontario, the laws of Ontario should generally govern. If I'm working in Alberta, if I'm working in British Columbia, those laws should govern. So you definitely want to give us a shout, because it looks like you're going to probably have a lot more entitlement and a lot more protection than you would if you yourself were working out of somewhere in the US. I've got another question in from Jay, who's saying, in BC or any other province, would an employer be able to put in a rule of English only in the workplace, or is that discrimination? It could be discrimination, potentially. I think it depends on the reasoning for why it's English only, and also how they actually enforce that policy. Because obviously it's not going to be a huge deal if someone is speaking a language other than English in certain contexts. Clearly, if all the customers or clients speak English and you don't, then yeah, there's probably going to be an issue as far as your ability to communicate with that person. So it kind of depends on the sort of the rationale behind why there's this English only in the workplace. It has to really strike at the core of the business and the way the business runs. I don't think it can just be some arbitrary decision. There's got to be sort of a bona fide reasoning or rationale behind it, or it's got to be a situation where you yourself don't speak English and they need you to speak English in order to do the job. Otherwise, it can be a problem. I mean, language, as far as I understand, is not necessarily the most common human rights related basis for raising things, but there could also be ulterior motives as well. So, for example, having an English only policy, while it's sort of focusing on language, there could be sort of a knock on effect as far as maybe someone's ethnicity or race is concerned. There's a lot of overlap in terms of that. And that's where you can definitely get into some of the human rights components and kind of almost look behind what their policy is and get to the bottom of where the issues lie. And for sure, there could be discrimination or human rights violations in place. So I think with some more added context or information, Jay, I could probably answer that a bit better. Oh, I see you've got another comment here. To avoid miscommunications in the workplace and avoid any issues that could arise. I mean, look, you want to be able to avoid miscommunications and avoid these issues that could arise. I think that's a legitimate business practice, but I just question whether or not you need an English only policy to sort of have that practice followed, or if you could have a situation where, maybe other languages can be spoken, but you're still able to communicate effectively, and there's still not an issue of miscommunication. Like clearly, if one person's talking in one language and the other's in another, yeah, there could be miscommunications. But that's not to say that I can't maybe have 2 or 3 languages I know and use them all, as long as there's no miscommunications. So I think that's a bona fide business rationale to make sure there aren't any miscommunications, but it just depends on how far they take it. Because if I just communicate in English 99% of the time, and then 1% of the time I speak in some other language regarding something that's not really material, is that going to be sensible to then penalize me for doing that? Probably not. It might be a technical breach of their policy, but it's not going to strike at the core of anything. So then it kind of depends, like I say, how they run with it and how they treat you if there are these supposed violations. I think it's relatively common as well, Jay, for the interview to be done in English, again, depending on where you are, where you're living, what the context is. And I think it just goes back to what the company's sort of MO is. Are they a company that primarily deals with customers speaking English, in which case they may want to make sure that you have a grasp of the language in the interview process. So yeah, it's just really contextual and sort of case by case driven, but I could see the potential for misconduct here in terms of applying this policy in if not a discriminatory way, then at least in a bad faith manner of some sort. So definitely also open to having you give us a shout. We can kind of delve into a bit deeper and get some of those other questions answered. I'll answer one more question just because I'm running out of time here. So I've got a question in from Kieran, who's saying that they were let go without cause after they complained about their manager, who had a history of bias against them even before the manager, and they always felt they were after me to undermine me. Yeah, so not a totally uncommon scenario. First of all, if you're let go without cause, you should be getting severance. So the first question for me would be, what have they offered upon your termination, and making sure that the severance package is at least fair as far as a without cause termination goes. So that's number one thing I'd want to look into. The second thing obviously has to do with maybe some ulterior motives. or underlying issues between you and this manager. So I guess the question is, when you say there's a history of bias against you, what is that bias? Because I run into this a lot where people will have problems with their manager and they'll say to me that their manager is treating them in a way that they're not treating anyone else. And so then I ask, well, why is it? Is it discrimination? Because a lot of people like to use that word. And a lot of times what people mean by discrimination isn't so much that they're being discriminated on, say, their race or their gender, but they're being discriminated in the sense of being treated differently. But then the question is, why are you being treated differently? Is it because of the color of your skin? Is it because you're pregnant? Is it because of your disability, right? All things that are covered under human rights. Or are you being treated differently because the manager doesn't like you, doesn't like your personality, there's a clash between you two, and they just have a disliking towards you, but not a disliking based on a ground under human rights? That's not to say that it isn't bad. It could still be bad faith 100%, but it may not necessarily technically qualify for discrimination for human rights purposes. So, but that's definitely a part two of your situation, is you want to try to uncover the underlying motives for letting you go. Because if you are let go in bad faith, and I know that's a broad sort of term, it's a pretty big umbrella you can put things under, but if you're let go in bad faith, you do have the possibility of getting extra compensation for the reasoning or the way in which you were let go. Even if on paper it says without cause, that's not to say that there can't be bad faith, and you can get extra damages on top of that full severance package that I was mentioning for that. But for me, it just comes down to whether or not that bad faith is related to a ground protected under human rights or not. Because if it is, then you can still go after them for extra compensation, damages for bad faith, but then there's that extra layer of the human rights component, which can also open up a can of worms and potentially give you more leverage and something more to go after in terms of the end of your time at that company. But that's going to do it, though, for my time today, everyone. I do thank you for your questions. I realize there may have been a few questions that I did not get to on today's show. But not to worry, we have these things going on a lot every week, whether it's with me or another colleague or another person at my firm. In fact, just down below there, you see this Thursday, the 21st. So a few days from now, Haley will be here, and she'll be doing the exact same thing I'm doing, trying to answer as many questions, all things employment law related. So for those of you who I didn't get around to answering, get your questions in for Thursday, at least with Haley. And other than that, I know I'm going to see you all in the near future at some point again. So thanks again for attending. I hope you enjoyed today's session. Do take care and definitely enjoy the rest of your day, and have a great Monday. Bye for now.